This Michigan judge hates your right to property. Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. For today's lecture, ladies and gentlemen, we're going to be discussing a very controversial case going on right now in Michigan involving a judge by the name of Kelly Kostin. Now, Kelly Kostin graduated from the University of Detroit Law School, or School of Law, which I know, to everyone's surprise, is another law school accredited by the criminal Marxist organization named the American Bar Association. So it shouldn't come as a surprise whenever you hear about all these rumors of exactly how she's ruling, the procedure she's allowing, what she calls a difficult case of self-defense, because that's exactly what she was taught by the American Bar Association. It isn't to favor and protect the citizens, it's to do everything possible, actually, to undermine the citizens, their God-given rights, their liberties, and of course the whole framework, the whole founding of, first, the states, second, the government, and three, the union between the states. So first, I'm going to show you the actual video evidence that was submitted to the court that shows exactly what's going on with this case between Mr. Dayton and 5 or 6 other individuals that tried to burglarize Mr. Dayton, and Dayton successfully defended his property. I'm going to show you the video, show you the evidence. I'm going to show you what Miss Kostin says about the evidence and how she's elected to proceed because of the difficult case of self-defense that is trying to be made. So let's go ahead, zip on over to the video evidence. I'm actually going to go ahead and hide my webcam just for this video because Mr. Dayton is down here in the corner where my head is conveniently floating. There, so let's go ahead and watch this video evidence of a supposedly difficult to understand self-defense situation. So here you have 1, 2, 3, 4, 5, and 6. 6 burglars, hooded, masked, looks like in black lock, forcing open a garage door. There's 2, 3, 4, 5, 6. So there were 7 in total. 6 assailants going into the garage. There you have Mr. Dayton. So this is an instance that Miss Kostin would consider a tough case of self-defense. 6 masked, athletic build assailants force their way into your garage, detached or not. Force their way into your garage that's closed off. It's 1 o'clock in the morning. Despite all of that, Ms. Kostin's going to say this is a difficult self-defense case, that there isn't a immediate, clear, reasonable, honest belief that there was imminent threat to Mr. Dayton's life or serious bodily injury. So let's see what Ms. Kostin says about the footage.
Obviously, this is a very difficult case because you do have...
Obviously, it's a very difficult case. There are 7 people trying to break into your garage, and it's 1 in the morning, and they're all masked, and your garage door was closed, so they really wanted to get in. Yeah, that's a really tough case of self-defense. Very, very difficult to decide.
Some empathy and sympathy for the defendant, understanding that his property had been broken into. The testimony looks like at least twice prior.
So Mr. Dayton tried to go through the peaceful diplomatic channels, and it looks like they didn't do anything. In fact, according to the testimony, when he went to the police department, they said, you should just beef up your security. So how is it that Mr. Dayton is supposed to expect the police to do their job when he went to ask for help, they told him, well, time for you to just help yourself?
To this incident, understanding, and there could have certainly been some real fear on that evening, but
could have. It's 1 a.m. There are 6 masked, athletic-built people, male or not, breaking into your closed garage.
the court also notes that the law does not allow you to use deadly force to protect your property. In this particular case, it was a detached garage.
Completely irrelevant.
The defendant in this case put himself in the situation.
Right, Mr. Dayton put himself in this situation, not the 7 assailants who voluntarily trespassed, who voluntarily forced open a closed garage door, who voluntarily then went into the garage, who voluntarily... This is just so ridiculous. The long-standing Latin legal maxim, voluntas non fit injuriam, answers this case instantly. These 7 criminals, these 7 trespassers, voluntarily trespassed. They voluntarily broke into Mr. Dayton's property at 1 a.m. So they weren't just walking down the street and saw something shiny that they really wanted. It's 1 a.m. There are 6 of them, masked. How is it that Mr. Dayton put himself in this situation? Therefore, self-defense isn't directly deducible. But the burglars didn't put themselves in this situation. In fact, if I was the family of the burglars, I would be filing a claim against the police department, since Mr. Dayton went and tried to go through that channel to get this resolved, and instead of the police department doing their job, they were neglectful. Maybe if the police department hadn't been neglectful and done their job, this wouldn't have happened. Maybe. But why is it that Miss Kostin is willing to blame Mr. Dayton because he supposedly put himself in this situation, but isn't going to hold to account the 7 or 6 burglars, 7 trespassers, for them putting themselves in this situation? Mr. Dayton didn't invite them. In fact, he had the garage door closed. There was 0 enticement, 0 reason for the burglars to do what they did. Why don't you mention that, Miss Kostin?
The self-defense argument becomes more difficult when the video shows and the evidence shows that he shot into the garage blindly twice.
And what are the reasons that someone shoots blindly twice? Reckless or fear of life. So you have to either prove that Mr. Dayton was being reckless, or he had an honest, reasonable belief that his life or serious bodily injury was imminent. And considering that it was 1 a.m, considering there were 6 assailants, all masked, that latter option seems to be the more probable. So again, why are you, Miss Kostin, assuming Mr. Dayton, in his reasonable actions, supposedly didn't have an honest fear of his life? 6 versus 1 at 1 a.m. Why, Miss Kostin?
For any of the people, the burglars or the people inside exited, the video, the evidence, that being the video, clearly shows that he was shooting at the people who were inside in the garage, the people who were attempting to burgle the garage. He was shooting at them as they were running away. So that, in and of itself, is certainly probable cause to show that he did intend great bodily harm.
So now that we've heard Miss Kostin's opinions about this matter and how it's supposedly not a clear-cut case of self-defense, let's consult the law that she's likely referencing and the Michigan Constitution, which preempts that law. So let's go ahead and jump on over to that statute. The statute being Act 309 of 2006, the Self-Defense Act. It says here, short title, 780.971, this act shall be known and may be cited as the Self-Defense Act. 780.972, use of deadly force by individual not engaged in commission of crime. Conditions. Section 2, Article 1, subsection 1. An individual who has not or is not engaged in the commission of a crime, which Mr. Dayton wasn't, at the time he or she uses deadly force, may use deadly force against another individual anywhere he or she has the legal right to be, which he did, with no duty to retreat. That includes a detached garage. If either of the following applies. A, the individual honestly and reasonably believes that the use of deadly force is necessary to prevent the imminent death of or imminent great bodily harm to himself or herself or to another individual. Another great question about the events that transpired within the garage is, did the 6 assailants flee before or after the shots were fired? Because if they fled before, that means, oh, they got scared by Mr. Dayton and feared for their life. If they fled after, that suggests that there was some attempt made against Mr. Dayton, and he very quickly, probably fearfully, hence the 2 shots blindly fired, made a defense for his life. Maybe that's what happened. B, the individual honestly and reasonably believes that the use of deadly force is necessary to prevent the imminent sexual assault of himself or herself or of another individual. Second, an individual who has not or is not engaged in the commission of a crime at the time he or she uses force other than deadly force may use force other than deadly force against another individual anywhere he or she has the legal right to be, with no duty to retreat if he or she honestly and reasonably believes that the use of that force is necessary to defend himself or herself or another individual from the imminent unlawful use of force by another individual. So if we apply what Miss Kostin is trying to say, which on its face sounds reasonable, on its face sounds congruent with what this law is saying, it would be untrue. Why? Because it would be lying by omission. You're not taking into full account exactly what this law has to comply with. What does this law, given what we know about the Michigan Constitution, which we're going to read over, given what the Michigan Constitution provides, what does this law have to include? This law has to include, in the understanding of individual, that individual's property. Why, might you ask? Because Article 1, Section 11 of the Michigan Constitution secures to all persons their houses, papers, possessions, so on and so forth, from unreasonable searches or seizures. Now, the argument you'll hear about this is, well, Caleb, obviously these clauses apply only to law enforcement. Are you so sure? Do you see in any of these clauses or any other state's equivalents, or even Article 4 to the Bill of Rights in the U.S. Constitution, does it say that this applies only to law enforcement? This applies only to courts? This applies only to legislatures and executives? No. What these clauses represent is that third God-given right that's directly enumerated and recognized in the U.S. Declaration of Independence. Now, in the final draft, it says the pursuit of happiness, but in the original draft, it says the pursuit of property. And if we take into consideration the founding generation's most influential thinkers, like John Locke, or the thinkers who greatly influenced the founding generation, like John Locke, he said, if you don't have the right to property, all of the other rights fall. So with this law, and she's likely referencing, individual, preempted by the definition and standards outlined in the Michigan Constitution, includes property. Includes everything that is under his control, that is in his name, under his authority. But further, you don't even have to make this argument. If it's the case that at 1 a.m, 6 athletic build, masked people abruptly are trespassing on your property, where you expected there to be security because you closed the garage door, so you expect no one to be there. How could it be? What better instance could there be of a reasonable, honest fear of life, of imminent, serious bodily injury, when you are outgunned, outmanned, 1-6 in the dead of night by masked, athletic-built people? If that's not a reasonable, honest circumstance where you reasonably and honestly fear for your life, fear that imminent threat, imminent bodily injury is about to be made on you, then what is? Being outmanned 6v1 isn't a reasonable, honest fear for your life or serious bodily injury? How else is Mr. Dayton supposed to secure, using Article 1, Section 11 of the Michigan Constitution, how else is he supposed to secure his property? Because he's already gone to the police twice, and they said, well, you just got to beef up your security. What is he supposed to do? So to Miss Kostin, how in the world is being outmanned 6 versus 1 at 1 a.m. in the morning not a reasonable, honest fear of imminent threat or of imminent serious bodily injury? Second, how else is Mr. Dayton going to uphold Article 1, Section 11 of the Michigan Constitution? How is he just supposed to secure his person, houses, and possessions from unreasonable seizures like theft and burglary? Or are you going to try to argue that the theft and burglary was a reasonable seizure? You can't. There is no argument to be made. You can either conspire with the criminals, you can either conspire with the burglars who voluntarily put themselves in the situation. Not Mr. Dayton. Mr. Dayton did not put himself in that situation. He did not invite the burglars. He did not invite them to trespass. He did not have the garage door open. So there was zero invitation. No, Mr. Dayton did not put himself in this situation. The burglars did. The burglars chose to trespass. The burglars chose to force open his garage door. The burglars chose to invade his garage, detached or not. And the burglars chose in a group to outman this homeowner. And you're going to side with them in violation of Article 1, Section 11. You're going to infringe upon Mr. Dayton securing his person, his houses, and his possessions from an unreasonable seizure. You're going to deprive Mr. Dayton of that, or even threaten to deprive him of that recognized right before you hold to account the burglars and the trespassers. That law, the self-defense law, has to include, because it's preempted by the Michigan Constitution, protection property. You may not like it, but until the Michigan Constitution, Article 1, Section 11 is amended, it is preempted. The self-defense law is preempted by the Michigan Constitution. So I'll say it in summary, very concisely for you, Ms. Kostin. Are you either going to be hypocritical and say Mr. Dayton put himself in this situation, but not the burglars? Are you going to conspire with the burglars and deprive Mr. Dayton of his recognized right to secure his property? Or are you going to uphold your oath to the Michigan and U.S. Constitution? Are you going to uphold the Latin legal maxim, voluntas not infit injuriam, and ultimately serve your purpose as a magistrate of the citizens of Michigan and protect the God-given rights of Michiganders, specifically Mr. Dayton? Choose. Are you going to side with the criminal, or are you going to side with the individual trying to protect himself from the criminals. And I'll ask this one last time, because this is so brutally clear of a self-defense case. And the only thing causing any sort of confusion is the mandated Marxist garbage that is imposed by the American Bar Association onto these supposed judges, better named activists in gowns wielding gavels. That's the only reason this confusion is being caused. The law provides for Mr. Dayton to be acquitted, to have never been charged in the first place. And before that act, before the Self-Defense Act, the Michigan Constitution, Article 1, Section 11, protects Mr. Dayton's right to do what he did. So you have zero ground, prosecutor and Ms. Kostin, to continue holding Mr. Dayton liable for or responsible for any supposed criminal act. So if you have any questions about this topic, maybe you think I'm totally off my rocker here, or maybe there's a legal topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to equip you with the necessary skills and information, such as this, to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope y'all have a wonderful day, and until I see y'all in the next lecture for the next topic, I bid you all farewell.